Welcome to Advisory Opinions. I'm Sarah Isger. That's David French. And this is the long-awaited episode that it's maybe 4-5 years in the making, David.
It is.
Because
It is.
today we have a guest who is going to take on originalism head on. And maybe more importantly, that guest isn't just any guest. It's Judge Edmund Sargus from the Southern District of Ohio, who's come to, really explain a different judicial philosophy that we've been having a conversation back and forth now for about a year. I met Judge Sargus at Legal Eagles in Gettysburg last year, and it's been one of the most rewarding conversations of my legal career. And Judge, I'm so thrilled that you're here and willing to share some of your thoughts with our audience.
Well, thank you, Sarah, and thanks to you and David for inviting me. As you know, I am a very avid listener of the podcast, so let me first give kudos to both of you. I really enjoy that you are able to address controversial subjects in a way that treats different sides of the debate fairly. I don't think we do enough these days to talk to each other about divisive issues. I think people, and I'm one of them, oftentimes avoid topics like this so we don't end up getting in arguments with people we respect and like, but don't want to necessarily disagree with. So what I'm hoping we can do today is to ferret out different ways of looking at constitutional interpretation. I will tell you as we begin, I am not a believer that one size fits all. I think originalism has its place. I think the common law organic view has its place. And I should also add a caveat. As a district judge, the one thing I tell new members of our court when they start, we never, ever get the final word on major issues of constitutionalism. The losing side will take it to the Court of Appeals. The Court of Appeals owes us no deference when it comes to a pure legal question. So I've written some cases on some important issues, a few of which have mattered just in the scheme of things. We do obviously apply the Constitution in Section 1983 cases a lot. But when I say apply, it's more to see if a party has enough to get to trial, and then we try the cases. But making new law on fresh constitutional issues is not my day-to-day work.
Well, Judge, I have to say, I'm so excited you're here. Very happy to have this conversation. Really been looking forward to it. And I just have to share the most Sarah thing ever, listeners. So I get an email, and it's all caps, says, "Hold on to your butts." And I'm like, what is this? What is this? And it's Sarah announcing that Judge Sargus is coming on the podcast, which I'm equally excited about. Like, I've never heard the "hold on to your butts" phrase. I thought Sarah came up with it. I now know it's Samuel L. Jackson. And then I look up, and in the two line, Judge Sargus is included. And I'm practiced for a long time, and I have this sense that when you're interacting with a judge, even in social circumstances, there's a degree of formality, right? There's a degree of we latch into our talking to a judge voice, if that makes sense. And I just thought, like, that is the most phenomenal, like, just best. Hey, this is a great ceremonial of just treating people like people. I love it.
Look, law students, do what I say, not what I do. This was not, to me, that's like my highest, like, OMG, but like from the 90s. It's not appropriate, and I shouldn't have done it. Okay. Judge Sargus.
And we can take that out of the podcast if you want.
No?
Oh, I like that. I like that a lot.
Judge Sargus, like David likes to say, where you stand depends on where you sit. So I thought we should start with, how would you say you got here? You were the U.S. attorney. You were appointed by President Clinton. How did you become a judge?
Everybody has a story, as you know. So I grew up in a little town of St. Clairsville, Ohio. Wonderful little town of 5,000 people, about 10 miles from Wheeling, West Virginia. I knew growing up I wanted to be a lawyer. My late father was a lawyer. I also enjoyed government. My father died very young, but he was in government. He was a state senator. Some people grew up memorizing baseball statistics. I could tell you the county chairs all around Ohio when I was 15 years old. So I eventually ended up working campaigns for two U.S. senators who became close friends, John Glenn and Howard Metzenbaum. And when the position came open for U.S. attorney, it was, I wouldn't say that I was the obvious choice. I would say I was their choice, and did that job for about 3.5 years. And a judicial vacancy came open, and I've been in this job for the last 27.5 years. I also practiced law for 15 years in a little town. I always like to channel Abraham Lincoln when I tell you some of the disputes had some pretty interesting rings to them, neighborhood disputes that could escalate sometimes. We did a lot of different kinds of cases. Ohio has a funny law that if you're a farmer and you put a fence on one side of your property line, you can bill the other side for half of it because they're getting the benefit. And I did a few of those. I had a psychiatrist who bought a farm as a place to get away. And the neighbor who was a farmer didn't like him and wrote a nasty letter saying, I'm building a farm 1/4 of the way across our common boundary, and you're going to pay for half of it, thinking he'd drive him away. So the psychiatrist had me send a letter back, oh, no, not 1/4. I'm building the rest of it. And you're going to pay me the half that's much more than what you had planned on. And the matter went away. So I had a lot of cases like that.
And you're married to a judge as well.
I am. And she
Your poor children.
I know that it is unfortunate for them. But yes, my wife was a judge before I was. She was a common pleas judge in St. Clairsville for 24 years and had some very interesting cases herself.
Yeah. What is a judge of that? Like, what does she do? Because I think our listeners know what a federal judge does. We
Sure.
don't spend a lot of time on local judges.
In Ohio, the common pleas court is the highest level court. It would be comparable to the district court, only under state law. So felonies, civil cases, equity powers, the whole 9 yards. What we always joked about is when someone filed a lawsuit that she drew, and she was in a 2-judge court, and the other side removed it to federal court, sometimes they'd bounce from one Judge Sargus to the other. And I'd always get a big kick out of that.
Judge, I'm convinced that the best dinner companion that you can find is someone who's practiced law in a small town for, say, 15, 20 years. Because the stories that they are going to have are going to absolutely blow your mind.
Yeah, that is true. The law walks in the door, as we call it, and people show up with problems. And yeah, one of the things you can't do much in a little town is specialize. So
right.
At a certain point, we didn't do any criminal work, but the civil side is you can guess everything from black lung cases to tort claims to all sorts of things.
All right, let's do this. So I thought perhaps the best place to start is Brown versus Board of Education, because
Sure.
I think across the board, regardless of your judicial philosophy, you want Brown to come out the right way. And so it's almost a reverse engineering thing. We can go through various judicial philosophies, but you need to make sure that Brown v. Board of Education comes out to say that racial segregation in schools is unconstitutional, that separate but equal is unconstitutional. And what's sort of fun about also starting with Brown v. Board of Education is that the opinion itself is incredibly short, and there's just so little to it. It was a unanimous opinion. If you remember, it was argued twice because there was a lot going on at the court at the time. They were basically waiting for some changes to happen to some court personnel. And this was the new Chief Justice Warren's, really his first major case. And of course, he was going to go on to have a lot of major cases, though none ever, I think, as big as Brown, really. And the opinion says a few things. One, it says, we looked at the 14th Amendment, and you know what? We can't tell either way. Shrug, moving on. Second, we don't necessarily think that racial segregation is a problem exactly, but like that separate but equal is inherently unconstitutional. But, and then the opinion really hinged on this like psychological data that even if the schools are totally equal in teachers and quality and all of those stuff, there is a psychological impact of segregating children that makes Black students feel inferior, and that is bad, and therefore school segregation is unconstitutional. It's like kind of a weird opinion that I'm not sure a lot of people would necessarily defend as that judicial philosophy being their own. And I think part of the reason why it's kind of fun is because there's like only 6-paragraph opinion. It's really short. You can take the facts of Brown and say, here's how it should have been decided in terms of the judicial philosophy and reasoning. So, Judge, we've talked a little bit about Brown from an originalist standpoint. You think that originalism would not get to the unconstitutionality of racial segregation, and more to the point, and I think you're going to call it common law traditionalism. You think that it is the better method. So take it away.
Well, first of all, the Supreme Court itself, 9-0, said that the answer would not be found in what the framers of the 14th Amendment and the ratifiers would have said. I've gone back and read the debates, and there's no mention of Blacks and whites going to school together. There's a lot of history, and there are bits and pieces we can take, as you'd expect. This was ratified by 3/4 of the states. There are a lot of people speaking in the floor debates. There are a lot of things said. One of the main sponsors, John Bingham, who, by the way, would have been my member of Congress had I lived in St. Clairsville in the 1860s. He actually went to school with African Americans and had lifetime friendships with the people he went to school with. So you can look at him and make a little bit of a point. But I think the important thing is, in Brown, the Supreme Court asked the litigants to brief something close to original intent. What did the framers of the 14th Amendment mean when it came to school segregation versus integration? And they said two things. One, it can't be discerned. And two, in the end, it really isn't going to be what determines the outcome. That instead, if we look at a common law approach, meaning one that starts with deference to precedent, continuity being a good thing, and a break with the past only when necessary. They focus, as you remember, on education having fundamentally changed from the time of the ratification of the 14th Amendment in 1868 to their decision in 1954. It had become such an important feature in American life that the foundations for Plessy versus Ferguson, for example, were no longer good law. So as you know, Justice Scalia took a shot at this in his dissent in Rutan versus the Republican Party. And the statement he made, and I agree with it, was that, in his view, the 14th Amendment requirement of equal protection of the laws, combined with the 13th Amendment's abolition of the institution of slavery, leaves no room for doubt that laws treating people differently because of their race are invalid. Completely agree with that statement. I don't agree that's originalism, though. I think that's something very different.
I think that's a great place to kind of define our terms, because one of the interesting things about originalism to me is that when I was learning originalism, I felt like I learned it in a way that was a little deceptive. That advocates of originalism sort of put it like, okay, and I've used this analogy before, it's like you're an archaeologist and you're digging and you finally find like the stone that demonstrates that King David actually existed, back in biblical times or whatever. You're digging through history and you're finding the nuggets that really make something sort of indisputably, one reading indisputably more correct than the other. Whereas in reality, it's actually more of a framework for how we decide things. It's not something that's going to guarantee a particular kind, that two originalists, in other words, can disagree on the same case. And so, which was not something that I had sort of thought in my youth when you're talking about originalism. And I've now read a lot of different kind of definitions of it. Is it original public meaning? What is original public meaning? The text, history, and tradition approach. What does that mean? How do you define originalism, Judge? When you hear someone say, I'm an originalist, what are you hearing them say?
Well, I'm going to start on a light note. You and Sarah have put me to my steps over the weekend. And you had an article within the last week in the New York Times,
Yes.
speaking of originalism, with a definition. And it starts with what you just said, to discern the common, ordinary meaning of the words.
Mm-hmm.
And second, at the time of the document's adoption.
Mm-hmm.
Now, to be clear, I think there are lots of times originalism can be really helpful in deciding how to interpret the Constitution. I wouldn't say forget it. I think what's oftentimes going to be absolutely definitive is just the simple words of the text. When the Constitution says you have to be 35 to be president,
right?
We wouldn't be debating, maybe we could be debating this year whether people were too young or too old, but the courts aren't tasked with that. The words are absolutely clear. That's the end of it. It's words like, in the Brown case, equal protection, due process. Those are the kinds of things where I think originalism clashes with a common law approach, because the world has changed. The common law assumes progress, by the way. Originalism assumes going backwards. I think the two pull in different directions, but at different times, they may speak to a particular part of the Constitution.
So I think there's also the way that textualism interacts with originalism that we have to talk about in order to make some progress here.
Yeah.
Because, and I'll use Bostock as an example, and mind you, there was a big fight among conservatives over the textualism and originalism of Bostock. And look, the shorthand is that textualism applies to statutes and originalism applies to the Constitution, but that really you're doing the same thing. Bostock was statutory, so we use textualism for that. But I also think that intuitively, you think about different things when you use the word originalism and you use the word textualism. So I want to use the word textualism a little bit, is what I'm getting at. So in Bostock, it was about the word sex discrimination, basically. And there wasn't really much question that at the time of the Civil Rights Act, nobody thought that the word sex would include a man putting on women's clothing to go to work. But what Gorsuch was saying was, nevertheless, that is what sex meant. You were discriminating on someone based on the characterization or stereotypes of their sex. So skirts aren't inherently one thing or another. So if a man wears a skirt, the only reason you're mad at him is because of this stereotype that women wear skirts. And therefore, if he were a woman wearing a skirt, you wouldn't have that opinion. Therefore, you're discriminating on the basis of sex. Okay, that's like my rough Bostock thing here. So when we think then back to Brown and about equal protection, I think you're right, the originalism that people think of is, would they have thought that school segregation was constitutional at the time of the ratification of the 14th Amendment? But a different way to think about that is, when they said equal protection of the laws, whether they understood that they were including school segregation or not, did they mean that you could not distinguish between two people based solely on their race? And I will grant you that actually, even the historical record on that isn't 100% one way or the other, as we learned during the affirmative action, briefing and oral arguments at the Supreme Court in the Harvard case. But it is different. And I think this gets to a problem with all forms of judicial philosophy. At what level of generality are we doing this game? And, Justice Breyer has a version of your, he wouldn't call it, I don't think, common law. He calls it traditionalism. But it's the same idea. His is a purpose-based test. What was the purpose of this law, as best I can discern it, and how can I best effectuate that purpose? But the problem is, what level of generality are you going to define the purpose? Because at some point, the generality of any purpose is, well, they were trying to make the country better, and so I'm going to come up with the way that makes the country better. So that is my pushback on textualism versus originalism definitionally, and I'm not sure it's a good thing for textualism and originalism, because it means that you can kind of play a little fast and loose. Is it whether they thought it would apply to this specific question back then, or is it simply what the words meant back then?
Well, first, I'm not a big ism person, and we'll put common law. We'll call it common law ism, just so I haven't excluded that. But the Bostic is a great example of the difference between originalism and textualism, as you said. And one of the arguments for that distinction is that if Congress disagreed with the interpretation of the statute, it could amend the statute. Not so when it comes to the Constitution. But two things I would argue in the Obergefell case, Justice Kennedy had to know that you're not going to go back in the 14th Amendment ratification period and find any mention of gay rights. Didn't exist. We know that. And yet, I love his quote, "The nature of injustice is that we may not always see it in our own times. The generation that wrote and ratified the Bill of Rights in the 14th Amendment did not presume to know the extent of freedom in all of its dimensions. So they entrusted to future generations a charter protecting the rights of all persons." I love that. I think that's exactly right. I'm going to make your case harder on Brown, okay? Brown, there may be some ambiguity in the historical record. That's what the Supreme Court said. How about miscegenation laws? There's no ambiguity. I went back and read this morning. This was the canard the opponents of the 14th Amendment would use. If you pass the 14th Amendment, then your daughters and wives are going to be marrying freed black slaves. And the Republicans uniformly said, that's a bogeyman, that's a bugbear was one of them. They had all sorts of words saying, whenever we get into this debate about African Americans, you always pull this out. Everybody knows that's not what this is about. They completely disclaimed any intention to find a constitutional right of blacks and whites to marry. Yet in 1967, a unanimous Supreme Court finds exactly that. That's where originalism can't take you. Where traditionalism and common law will take you there, though.
So this gets to another fun question, I think, about different judicial philosophies. And it's worth noting, Justice Scalia did not think that originalism was the be-all and end-all. It was something like democracy, right? It's the worst form of judicial philosophy except for all the others. It has faults, but those faults are less than the faults of other judicial philosophies. And, he listed one of the faults as it's really hard to go figure out the history. It can be voluminous, it can be ambiguous, all of those things. And second, he said originalism could be a medicine, quote, too strong to swallow. And I think that's what we have here. Because we want the Constitution to have protected interracial marriage. Just like we wanted the Constitution to protect gay marriage, for instance. But here's the question, and this gets to a Congress do your job, but it's, I think, much easier to say, like, look, we have a Congress, they can do this, blah, blah, blah. It's much harder if you need a constitutional amendment. Now, I actually do not believe that interracial marriage needed a constitutional amendment. There was nothing that we were overriding in the Constitution. There's nothing that banned interracial marriage, but you certainly needed a statute to do it. So I think some of the question then that you have to answer is, wouldn't it have been okay if Loving v. Virginia had turned out the other way, and that the enormous amount of political pressure that would have been put on Congress at that point, because at that point, by the way, it was, the tides had very much turned on this question. Isn't that fine if then Congress just had to pass a statute and supersede a Supreme Court decision?
Okay, but to counter that in a nice smiley way, okay, on that theory we don't need.
Sargus is throwing emojis at me.
On that theory, we don't need a Bill of Rights. It would be better if Congress passed the Miranda warning. It would be better if Congress passed New York Times versus Sullivan. But we have a Constitution to make sure that certain kind of fundamental rights are not left to the majority. So waiting for Congress to act is another way of saying we're waiting for majority rule to overtake this. And sometimes that isn't going to happen. Or if it's going to happen, it's going to happen generations too late. That was the essence of our Constitution, was to enshrine these sort of fundamental rights and take them out of the will of the majority.
Of course, in the case of Brown v. Board of Education, the Supreme Court said that school segregation was unconstitutional, unlawful. They were ahead of the culture on that one. And so what happened? Schools did not desegregate for 10 plus years until Congress acted. So what I think the history shows is that if the Supreme Court acts before the culture, the culture waits for the culture. If the Supreme Court acts in a way that is already directionally where the culture is going, and here I'm thinking about Obergefell, then it just kind of happens.
Yeah.
You're right, maybe a few years earlier than Congress would have done something. And then you have Roe v. Wade, where the Supreme Court acts sort of different, like just sort of in a moment where it's unclear which way the culture is going. And then it creates 50 years of political havoc.
Let me push back a little bit on Brown versus Board. Certainly, there was a role for Congress to play. By the way, before Brown versus Board, as you know, I'm going to guess most of your listeners do, there were a lot of things happening in the 30s and 40s in the area of race relations. The military was integrated by order of the president. There were several Supreme Court cases before Brown that made it clear the court was taking a hard look at segregation. So this wasn't completely out of the blue. And in the 1950s, think of Little Rock, there were courts enforcing Brown versus Board. There was President Eisenhower sending in troops to make sure the order was enforced. So the country was moving. Truly, part of the country wasn't moving, though. And that's what this case did. So I think it did probably push school integration by at least a generation or two in some states ahead. Roe v. Wade, I want to be careful here because I could be stuck with some cases in this area. That's a different issue where the Supreme Court didn't settle the case. The extreme example I would use is Dred Scott. The Chief Justice at the time thought that the Supreme Court was going to put the slavery issue to bed, did exactly the opposite. So there are times in our history where the Supreme Court has pushed far away from public opinion, and they've lived to regret it. So I would put Brown in the category of one that worked, Dred Scott being the extreme opposite example, lots of cases in between. But the one thing we can say about Roe is that it did not settle the issue. And that's probably, I think, something we could all agree on.
So, Judge, this is where, let me make your case for you for a minute. And
I need all the help I can get.
Well, let me make your case for you for a minute in what I call the difference between good originalism and bad originalism. So I think of good originalism as when you're taking the words on the page as the words on the page of the Constitution they're paramount, and to the extent that any historical background helps us amplify or explain those words on the page to give them force and effect, that would be what I would think of as good originalism. Here's what bad originalism is. Bad originalism is when you have the words on the page and then you go into history to explain why the words on the page don't mean what they actually say. And this is where we get into some of the equal protection issues. And so, for example, if you had an originalism that privileged the words on the page more than anything else, you don't need the 19th Amendment granting women the right to vote, because it seems to me that denying women the right to vote is a clear violation of the term equal protection or privilege or immunity of citizenship. So in that sense, it feels like the 19th Amendment exists because there was a determined effort or a feeling or a sense or an original public meaning that equal protection did not actually mean equal protection. And that's why one of the reasons why I go back and as you were noting, Judge, I used a Judge Newsom's definition of originalism in a piece I wrote last week for the Times that talks about the most important element is text. Text is the most important element. And I feel like there's a version of originalism, and I've explained it poorly, that previously that weirdly enough de-escalates or de-privileges, de-emphasizes the text. And it seems as if some of the common law elements you're talking about actually in an interesting way might privilege the text a bit more by giving the text its full force and meaning over time. Is that a fair? Would you say that's a fair description?
I do. The trouble with words like equal protection and due process is that they're not self-defining.
Right.
So originalism, when it comes to women, would say, look, there was a push in 1866 to 1868 to put women in the 14th Amendment. It failed. So it's hard to see how a court could come along and say, wait a minute, equal protection means women have a right to vote. That took a constitutional amendment. Today, we see that as, well, that should have been an easy decision to make. Women should have equal rights. Blacks should have equal rights. We could say the same thing with the benefit of hindsight about gays. But there's more. And what is the limit? I mean, what groups are included? You know, you're familiar with the famous footnote in the Coraline Products case. They had a definition of what groups could be included that certainly wasn't from the text, wasn't from the historical record of the people who framed the amendment. But it did seem to me consistent with what our whole structure of government is supposed to be about, which is to protect minority rights from having fundamental rights infringed upon, but at the same time let the country be governed by the will of the people in all other regards. But I think equal protection is the hard one because it just doesn't have an easy. I used to have red hair before I turned gray, and I've always wondered if red hairs should be a group protected by equal protection. But so far, no one's bought that.
Well, David, though, under the Bostock reading, I think women would have had the right to vote under the 14th Amendment, right? Under a Bostock type of textualism, I mean.
Absolutely. 100% correct. Like a text privileged, a originalism that privileges the text to such a degree that you're only moving towards the historical meaning when the text, men can vote and women cannot, seems to be about as basic an equal protection violation as the words on the page could convey.
Right.
And yet the original public meaning was, oh no, equal protection does not mean this at all. And that's what I mean by originalism undermining text, as opposed to originalism amplifying or helping us understand text, if that makes sense. And that's been my issue with it.
Let me get a quick Justice Scalia story in here. There was a case, and I'm sorry I don't have the citation in front of me. It was pretty early, 1990, 1991. And I remember the facts. There was a male working on an oil rig, and it was a pretty rough place to work. He was gay, and he just had enormous amounts of harassment to the point he quit. He brought a lawsuit. And Justice Scalia said, sex means sex, that he had been a woman who liked men. That would have been fine, but he was a man who liked men. It was because of, that's the words from Title VII. And that was out there, didn't make a lot of news. And the Sixth Circuit, where I covered, had several cases after that that said gays were not protected by Title VII. So as a district judge, I'm in the spot of, well, the Supreme Court said the opposite, and the Sixth Circuit tells me it's not so. What do? I followed the Supreme Court. This was before Bostock, and then, of course, Bostock cleared it all up.
So let's get back then to Scalia's point that originalism is the worst except all the others. And let's talk about what tools you use in your common lawism to discern the meaning. Are you looking at things like the legislative record or purpose, like Justice Breyer suggests? You mentioned sort of the easy things, precedent, right. That you do, of course, look to the text, but it feels like everyone's willing to talk about the easy stuff that all sounds good. Get to the hard part of yours. What is the problem with common lawism?
Well, what I like about common lawism has a lot to do with where I sit in this system. I'm a trial court judge. And if I could digress sentencing for a moment.
Digress on this podcast? My goodness, who could imagine such a thing, sir?
What I hear in this demand for certainty, in other words, show us the principles, show us how cases should come out under a process, an ism, so to speak. That rings in my mind of the federal sentencing guidelines, is that we have to take the judging out of judging. We have to take any discretion out of sentencing. And then it's turned out over the last almost 40 years that they've been in effect, that it doesn't work like that. The cases are too unique. The different kinds of crimes are too varied. So what we have instead is a system that says, here's what a typical judge did over the last 30 years before we promulgated these guidelines. And that's a starting point for you. Start there. And if you think the sentence is too high, explain it. If you think it's too low, explain that. So I think there's a lot more judgment that goes into this in a specific case than just having an ism. But what I do like about the common law side is you start with what's the precedent. And that in most cases should carry the day, that we have an idea that the past wasn't all bad, that other judges got this right. Now, what's changed? Once in a while, in Brown, for example, or at Loving, things have changed, and you need to explain why they've changed, and you need to move it forward.
What had changed in Loving?
In Loving, what it's changed is 100 years of our history, that we, as a nation, began to realize that it was shameful how African Americans were treated, that they should have equal citizenship, and the public had moved in that direction as well. It's not a popularity contest, but it has some sense of where the public is and where certain rights aren't being protected. And the argument I would make is, just like with originalism, either one can get this wrong. The court could be too far ahead under a common law theory. They could. And you can probably use Dred Scott, the common law, and it would be a bad outcome. There are 3 amendments to the Constitution that overruled Supreme Court cases. So that's part of our history. The Dobbs case shows that over time, if an opinion's unpopular, that there's a way to change the composition of the court. But I don't think either originalism or common law approach is foolproof. I think our system is based on the idea that each branch of government is capable of mistakes. That's why we have the 3 branches of government. But I don't think one has an advantage over the other in terms of judges run loose, whatever you want to call it.
Can you give us an example of a time where you applied your common lawism and it came out differently from the way you would have wanted it to come out?
Well, I was going to, facetiously, but also in real life, I've only had one constitutional case where I felt I was deciding an issue cold from scratch. Do you remember a congressman from Youngstown named Jim Trafficant?
Of course.
Okay. So, fascinating guy. I'll cut this short because he could dominate the rest of the show. But he was expelled from Congress after having been convicted in federal court of income tax evasion and bribery. But he hung on to the bitter end. They actually had a trial on the floor of the House. He defended himself, didn't have counsel. They expelled him. In the meantime, there had been a census. The state government had reapportioned the congressional lines, and his congressional district basically was disappearing. So I think the vacancy occurred sometime in October of the last of 2 years of that term. As you know, the Constitution says no one can be appointed to the House. There has to be a special election, and it says the executive of the state must order an election. Well, the way the math would work out, if you put all this together, had an election, they'd get somebody in office towards the end of December. And the term ended in January, and the whole seat ended in January 1st to be exact. So both the chair of the Democratic Party, chair of the Republican Party wrote a letter to the governor saying, shouldn't do this, big waste of time, and whoever gets the seat is going to be gone in just a few days. So the ACLU sued the governor of Ohio at the time, Robert Taft. I got the case. There's really nothing comparable to that. So honestly, I looked at the text and thought, there's mischief here. If a Republican governor held up a Democratic seat for a year and a half, that doesn't have any appeal. There's also no sense of that happening here when both parties have asked the governor not to hold an election. So I basically said that this is a situation where the Constitution was meant to be practical. On the one hand, if there were any showing of any sort of abuse of discretion by the governor, I would order an election because the Constitution didn't have a maybe, it said shall. So just so you know how persuasive my opinion was, I was reversed 3-0 by the Sixer. So that's not the kind of case I normally bump into. It was a very kind reversal, by the way. And it was after they took the case, even though the term had ended, because they found it was capable of repetition, which was right.
So what did they say? Now I'm just curious.
That shall means shall, and that this could be abused, and there should have been an election. So, but no, what I wanted to emphasize is that this is not my daily line of work, where I apply originalism versus textualism versus common law. It's just a view from having looked at this, and I've always had a great interest in the history of the 14th Amendment.
One thing that I think is very helpful about this conversation, because again, I go back to sort of thinking about how these arguments were debated, or how these arguments were defined, and how we debated these things when I was in law school and as a younger lawyer, where you're sort of thinking through competing legal philosophies, is I think a lot of defenders of originalism say, we're really the only people who truly focus on text. But that's not exactly accurate. The approach you're talking about is also quite text heavy. It seems as if the divergence is how do we figure out when the text isn't self-defining? How do we figure out when the text isn't the term equal protection, as you noted, isn't self-defining? Where do we go when it's not self-defining? Not the text doesn't matter. And I think that this has kind of been the caricatured version of the opposition to originalism. Right. We originalists make ourselves feel better because we're the only ones who care about text. And that's not accurate.
In one aspect of the common law, the other case of interest is U.S. versus Jones. That's the GPS device on a car and whether a warrant was needed. If you remember the debate between Justices Scalia and Alito, it's interesting because Justice Scalia took us right to 1787, talked about what a constable would do and whether this was a trespass. And you remember Judge Alito's famous comeback that had to be either a small wagon or a very large wagon or a very small constable. They were analogizing the constable would be hiding in your wagon as it drove away and he'd know exactly where you went. And there are many times that what the framers meant is important, but in the modern era, when we're talking about a GPS device on a car, that sort of factual analogy, I think, at least in my view, isn't helpful. That's what I would call it. But the words themselves, because there are some things in the Constitution that are quite specific. The idea of having to identify the home to be searched, that's right in the Fourth Amendment. So anything like that has a clear meaning, that's the opposite of equal protection, I would argue. That's where the text needs to carry the day.
Okay, so how does common lawism differ from living constitutionalism?
It doesn't go backwards. It doesn't say as a starting point, what were they doing in 1868 or 1787? It's, okay, we understand how these cases interpreted equal protection before. We will be guided by those unless something significant has changed that would make us think that the foundations of the precedent no longer made sense.
Okay. How does common lawism differ from Breyer's purpose-based test?
I don't think it's purpose-based as much as a court being sensitive to, here's the example I would use, interstate commerce. Okay, if in 1789, the first Supreme Court of the United States had to find what is the meat industry? Is it intrastate or interstate? And in those days, if you killed a cow and didn't have some way to refrigerate it, it would rot in a day or two. So you couldn't have meat cutters in Philadelphia selling meat in New York City. Intrastate, not subject to congressional regulation. But now 115 years later, Chicago has figured out the refrigerated railroad car, and they have stockyards that can send frozen meat all across the world. That's changed. The factual underpinning of that 1789 decision isn't true anymore. The world has changed, and the law needs to change with it. That's where the common law tradition accommodates change. It doesn't change the principles involved, but it does change the application of the facts.
Yeah, this is so helpful to hear you articulate this, because I do think this is where you're really pushing on the things that trouble me, Judge. So let me take another issue, and this one you may not be able to really touch it because you may have cases. So let me just throw this out there, and you cannot respond or not respond. But for example, the Second Amendment, when it says the right to keep and bear arms. So an originalist says, arms mean, what is arms? What does arms mean? An originalist would say, okay, what we're talking about is weapons that are personal defense weapons, but also at the time were military grade weapons. In other words, the Brown Bess flintlock musket which was hanging on over the mantles of a lot of colonists' fireplaces, was also the weapon that the British regulars used. So therefore, if you're going to regulate an AR-15, which might be in your gun safe in your house, which is very similar, not identical, but very similar to the M4 that I carried in Iraq, originalism would say that's arms. But it seems to me that a common law ism approach would not look at it that way. It would say, well, you're allowed to have some weapons. You're allowed to have some weapons, but we can't look back to 1868 with the ratification of the 14th Amendment, which, incorporated the second, or go back to the 1787 Constitution and then the Bill of Rights, the ratification of the Bill of Rights after the 1787 Constitution, and then determine that. What are arms? That is a process that is evolving through precedent and case law. Is that, well, you may or may not be able to answer that, but that's how I would interpret some of the differences between the two.
Well, that's a great question. So in terms of a common law approach, I'm not sure how that would turn out. Mm-hmm. I don't sense, the country's divided on gun issues. I mean, polling says one thing, but there are people with strong opinions on either side. I doubt a decision from the Supreme Court would end this debate one way or the other. So there's a certain amount of, I would like to think, for people who really adhere to this common law idea, there should be a certain hesitancy of jumping into a great undecided political debate and taking a side. Mm-hmm. One thing the common law is supposed to do is maintain respect for the legal system and as a system of laws, not as a system of gratuitous policymakers. So I'm not sure the common law would lead to any great cataclysmic difference in mm-hmm. the gun area as opposed to originalism. I think, you can make originalism from the common law side very wooden. You could say, well, if we look to 1787, good luck with your flintlock, right?
Right.
But that I don't think that's the only way to view originalism. I like mm-hmm. what you said, which was the gun we're talking about would be comparable to what a soldier in the Revolutionary War would have carried. And then you make that same analogy today to an AR-15, for example. I know that's going to make some of your listeners upset the way I put it, but I think that's the kind of issue that unless the common law can identify some big change in facts that makes the earlier precedents challengeable and no longer good law, I'm not sure this is one where originalism versus the common law would make that much of a difference in the final decision of a court.
I love this. Judge Sargus, you've been incredibly informative and helpful, and we so appreciate you taking the time out of your Article 3 lifetime tenure to come talk to us about this issue.
Well, I feel very privileged to have a great conversation with the two of you. Thank you for inviting me.
Yeah, this has been a real treat, Judge.
Your second time on Advisory Opinions, because in our special Legal Eagles episode, we discussed your book on events transpiring in Wheeling, West Virginia.
Yep. Article 4, Section 3, how to create a new state out of an existing state.
And plug the book for us, because it's actually a pretty fun book.
Well, it's an interesting question of originalism, too.
Yes.
This is a very specific part of the Constitution. They were anticipating new states. They were also anticipating some states splitting in 1787, Virginia being one of them. Kentucky was split off. But the amendment, the Article 4, Section 3 says that if a state is split, the state being split has to consent. So the problem was Virginia seceded, but then West Virginia wanted to split off. And the question of what kind of consent did West Virginia need when the state that would otherwise give consent says we're no longer covered by the Constitution? That was the great dilemma in 1862, 1863. That's what our book's about.
But I love what West Virginia did to solve the problem. Because Virginia was no longer part of the Union, West Virginia peeled off, said, now we're Virginia, and us, as the government of Virginia, now gives consent to West Virginia to peel off, and then basically they disbanded their Virginia government and became West Virginia.
That's exactly what happened. And their biggest supporter, by the way, was one of the main drafters of the 14th Amendment, John Bingham. His district was right alongside West Virginia on the Ohio side. And his view was, once a government's in rebellion, it's no longer a Republican form of government. The federal government could step in, and West Virginia became a state. Not without a lot of grief, though.
And perhaps this brings up the practical side of judicial philosophy, because in the moment, it was incredibly important to have West Virginia separate from Virginia and part of the Union, because important railroad lines ran through there that could move supplies.
Yep, the B&O Railroad, the biggest railroad in the country at the time, the most important. And by happenstance, West Virginia happens to track those rail lines.
All right, what's the name of the book?
Seceding from Secession.
It's so good. I just love these little bits of our history, David.
I do too. I do too. I mean, we could have a whole podcast, which would be fascinating to maybe only me, about the way in which the fact that the Confederate States were in open rebellion against the Union, and the Union did not want to recognize the Confederate States as a belligerent power, because that would in many ways ratify the secession as a legal matter in an interesting way. But at the same time, as for all practical purposes, they were a belligerent power. And so how did the Union constantly shift between, okay, as a practical matter, we're treating them like a belligerent power, but as a legal matter, we're treating them as if they're just in open rebellion in a state of treason. It's really fascinating. It's a fascinating subtext history of the Civil War that involves the Emancipation Proclamation, that involves the creation of West Virginia, that has relevance to the ratification of the Civil War amendments. It's really the whole way the war was conducted with prisoners of war, etc. It's really fascinating. I mean, so somebody out there who's a legal scholar who wants to write that book, you have one sale. You have one sale. But Judge, I'm running and getting your book. So I'm fascinated by this question.
All right, Judge Sargus, thank you.
Thanks so much.